my legal practice, I not only have I engaged in litigation, I also handle conveyancing. I also handle mediation, and even negotiations between parties at an informal level, because of my expertise and knowledge in the law, and as well as the experience I have gained both in and out of the courtroom.
Thank you. Any special area of preference when it comes to the practice of the law?
Yes, mainly in litigation. I have a strength in family matters, particularly succession matters. That is the law of inheritance. And I also have a strong point in commercial litigation. Having, for the period that I was employed in the law firm of SM Chege and Company Advocates, I handled a lot of litigation involving insurance companies and banks. However, in my private practice, I mainly deal with one-on-one clients, I mean individual clients, as opposed to corporate clients. The reason for that being that I gained a strong basis at my pupillage, which I undertook with a firm of a deceased advocate called G. Kamonde Advocate, where I learned the rewarding bit of helping a client at an individual level, helping them resolve their disputes, helping them overcome their challenges in the law, and the satisfaction that comes from knowing that you have accomplished and helped a member of society.
All right.
Yes.
I'm sure being a litigator for quite some time now,
Yes.
and being a person who practices in our courts, there are certain things that you see amongst judges and amongst judicial officers that, as far as you're concerned, you would not want to bring on board. What are some of these issues if you were to be the successful candidate?
For me, my challenging factor several times, or let me say occasionally, is timeliness. Although I would say timeliness in the High Court is relatively observed, but in the lower courts, it's quite frustrating sometimes. So when
there's an issue about not keeping time. Anything else?
Delays in judgments and rulings, and sometimes even just reading judgments and rulings and feeling as if the judge or the magistrate did not put into consideration the evidence that was adduced and even the submissions that were put forth by counsel.
So we are talking about quality as well?
Yes, quality.
Have you ever considered that maybe judges and magistrates are greatly overworked, and hence that's why, in terms of the turnaround time, that tends to take a bit of time?
Well, as much as I appreciate that, I also, and in recognition of the fact that there's a lot of litigation nowadays and there's a lot of backlog, I also recognize that as a judge or a magistrate, in some situations, justice delayed is not served, it's not justice served. And there is reasonable delay, but then at some point it becomes quite unreasonable, and that is the point you start getting concerned.
And finally, from me, what special attributes then would you bring on board if you were to be the successful candidate and you are appointed a judge of the High Court? Diligence,
discipline, and commitment to the work that you are doing, and also realizing that the time that you're serving is not really your time, it is public time.
Thank you.
Thank you, Commissioner Mashari.
Okay, 3 questions.
Yes.
Now, we are looking for somebody who is distinguished.
Yes.
Because there are many applicants.
Yes.
Now, could you demonstrate to this commission?
Yes.
What is it that you think you've done in your career?
Yes.
that the experience that you've acquired that you think makes you, distinguished?
I
Can
will
you give
say,
specific examples?
yes, I will say I'm distinguished in the sense that I have contributed to the jurisprudence of this country in all matters, including even environment and land matters. I have seen a lot of my cases quoted in the Kenya law reports and even in other forums. Recently, I got called by a client telling me that she's concerned that she's seeing her name in some legal research in Australia. It was a labor matter that I had concluded in the year 2021. I just had to allay her fears that there's nothing wrong with your name being quoted as long as it's helping to improve case law. Apart from improving on jurisprudence, well, I have also, even in the cases in the Court of Appeal, I have seen many of them quoted. I recently noticed a new area in the Court of Appeal where the judges were saying that you cannot, the concept, the equitable concept that you cannot, should not, doctrine that you should not approach. He who comes to equity must come with clean hands. One of the, the appellant in the matter that I was handling had actually not paid stamp duty on the land that was under dispute. And therefore, the judges were of one voice that you cannot come to us and expect justice, and yet you're depriving the same government that is you're seeking a remedy from. So for me, that was outstanding. I felt honored for my argument to have been recorded that way. Apart from, yes.
Mm-hmm. So when sorry for cutting you short.
Yes.
So when you quote the cases that you think
yes.
have made a difference in terms of jurisprudence,
yes.
which then would you consider to be your area of speciality, where you think you've been most impactful? And again, as you say that, just be specific, in respect to the cases that you've handled in that area.
I will feel that I will be most impactful in the area of contracts, land law, and
Saying
family.
Where you've been impactful, not in the future,
yes.
in the cases that you've handled.
At conflicts, I feel I have balanced all the areas. The only area that I feel I have not delved into in detail is the constitutional law. Otherwise, in all the other areas, I feel very confident because I have handled over and over a lot of cases.
A final question.
Yes.
Now, if lawyers are to be asked to describe Agnes
Yes.
Njoroge,
Yes.
now, in their description of you,
Yes.
how do you see it looking like? And why would they describe you that way?
A person of integrity, a diligent person, straightforward, and this really discipline is my forte. Yes, and I have had even from colleagues discipline.
That's all for me. What about you, Justice?
Thank you. Now that you mentioned the Constitution, I think
Yes.
I will ask you a question in that area.
Yes.
Because if you are successful as a judge, complex cases will come before you for interpretation and application of the Constitution, especially even to determine the validity of a statute, whether the statute is unconstitutional. I want you to give me 3 areas or 3 considerations that you would be guided by to decide whether a statute is valid according to the Constitution or whether the statute is unconstitutional. What are the guiding principles in determining that?
If a statute is in conflict with the Constitution, then that statute must fail. It's not, the Constitution reigns supreme, and therefore anything short of the Constitution must fail. Another guiding principle will be whether the main principle or enumerated in that statute is in line with in sync with the Constitution. Even if it's not in direct conflict, but in a way it deviates from the objectives of the Constitution, then that statute will be invalid. If a statute does not
I've gotten two.
yes,
If there's clauses or provisions in the statute that are inconsistent with the Constitution,
yes,
and also the objectivity test.
yes.
The third one?
The third one will be if the statute or some portion of it really is not, is repugnant to justice, then it's unconstitutional.
Is the same as number one, but you will also ask what was the intention of the statute.
Oh
when
yes,
it
the
was,
spirit of the statute.
Yes, yes. The second question is, if you are successful in this venture and you are sent to a station, just tell us what are the 5 things that you would do to make your station as a judge efficient.
Thank you, Madam Chief Justice. I will first learn the habits or the habits of the people of that area.
They may be bad.
Sorry?
They may be bad habits.
Well, I would learn the people of the area, the good and the bad, all together. And I will learn how their conduct in court tends to be, especially the advocates. And on this, I speak into, I have practiced in many towns in my private practice, and I noticed that from town to town, you find peculiar characteristics. Like, for example, there is one court I attended severally, and I asked myself, are they always adjourning cases over there? You know, I would learn how to streamline the practice of the litigants as well as the advocates. I would learn also how to streamline the judiciary staff in that area, because they're the support staff. And I will also learn, I would also need to learn the common kind of cases in that area. Are they criminal? Are they constitutional? Are they land related? Because courts vary. Like if you go to the Eastern Province, you'll find a lot of accident cases.
Case audit, you do that?
Sorry?
Yes. Case audit.
Case audit, yes.
Yes.
I will also learn whether we have adequate or infrastructure in the courts that is conducive to litigants or people who approach the court for justice, and if see if there are any areas of improvement.
How would you deal with backlog?
I would go back to the issue of case audit and look at all the old cases first and understand why they have not been concluded. I will purpose to insist on prosecution of the older cases. And I will also ensure that I have a cost list that I can manage on a day-to-day basis, so that I don't have a very long cost list and at the end of the day I have not achieved much. Yes.
Justice Majaja.
Thank you. Just to follow up on the issue you talked about, delays in judgments and rulings.
Yes.
If you are appointed a judge, what would it you do
Yes.
to avoid delay in judgments and rulings?
first of all, at the hearing, I would endeavor to really be in touch and in sync with the proceedings so that by the conclusion, I know the salient issues and facts. And even as I wait for submissions from counsel, and by then, which I will also regulate, not, I would apply really the practice directions to the extent of how many pages of submissions you can make, so that, and then I will also limit the amount of time that people, or advocates, will take in submitting their submissions, so that we don't have someone taking 2 months to bring their submissions. And then I would also ensure that at the conclusion of each case, I have scheduled my free time so that I have a number of cases to write judgments on certain days. I will set aside days to really write judgments.
Okay. Let's go back now to the other topics. As a High Court judge, the majority of the appeals you'll be dealing with in criminal cases are from defilement. That's a fact.
Yes.
Under what circumstances would you uphold a conviction where the prosecution failed to call the doctor who examined the victim?
Circumstantial evidence?
Of under what circumstances?
If in consideration of the circumstances of the alleged offense, or the offense now, there could not have been any other person, or and it is clear that the offense was definitely committed. And for example, in an instance where even you find the minor is even pregnant, that is evidence.
And suppose there's no DNA evidence, would you still say the minor was pregnant and there was still no DNA evidence to show a connection between the victim and the accused? Would you still go ahead to convict?
Yes, in consideration of the circumstances under which the alleged offense occurred, after listening to all the witnesses and even the minor herself.
And if the minor was the only witness, would you go ahead to convict?
If the minor was the only witness, yes, I would.
Under what circumstances?
Under the circumstances that the minor was not in any interaction with any other person at the time, and also in consideration of how far along in the pregnancy they will be.
Okay,
yes.
Thank you.
Thank you.
Thank you, Honorable Chair. Counsel, I want to discuss with you briefly about your writing.
Yes.
You have presented 5 sample writings.
Yes.
I've read them, and I think you write very well. But now, when you are addressing in your submissions, written submissions,
yes,
and I believe also your oral, it must be the same way, you're addressing the court, the judge, the judicial officer, in the interest of your client. But now as a judge, and then in Kenya, it's an adversarial system. There you're pushing for the interest of your client. But now coming now to be a judge, you are an arbiter. How do you think you would wish to deliver your judgments, write your judgments? Speak to the parties.
I do not think I really got the question.
Okay. Language is a tool for communication by judges.
Yes.
And you have to deliver your judgment in a way that both stakeholders understand, including the public who will finally read your judgment. So how will you go about writing a good judgment?
Very well. I will go about analyzing the case. The
Writing.
case,
Yeah, analyzing and writing. They're all inclusive.
analyzing the case.
Okay, okay. How would you like to structure your judgment or ruling?
Oh, very well. I will start by stating the case, and then I will go into breaking down what are the issues, and then from there I will move on to what are the facts, what has been proven in evidence. And then I will go ahead and look at quoted statute. Even myself can quote statute that is not quoted by either of the parties, which I feel is applicable. And then I would reduce the law, the statute, and the facts in, on application of the law, the statute, and the facts. I will reduce it into a judgment.
Yeah.
Yes.
And the communication style, your style of writing,
Yes.
I've seen that you are very concise and your sentences are very short, to the point.
Thank you.
Is that important?
Yes, it is important, and I have been told by judges that I am concise in my pleadings and my submissions, so I feel it is important. I have come to think it's important. Yes.
What about the language? You know, law has so much complicated words. Res judicata, jurisdiction.
Yes,
How
it is.
do you write judgments that the parties understand you? And then finally, even I can see you said you are reported in Australia. You want people to understand you there, and you know English is not our language.
I agree. I acknowledge that words of common usage are very important. That does not mean simplistic, but there are words that are universally recognized in law, and so that no matter if you use the words in England, in the US, or in UK, in Kenya, in Uganda, anyone reading that judgment will be able to understand. I would endeavor to use words of common usage. Yes.
We have seen sometimes some of our judicial officers, even judges, sometimes they throw in some Sheng words. Would you use Sheng words? Like utadu?
Like I said at the beginning, if I get to sit on the bench, I know that I am operating on precious judicial time. I mean, that is public time, not my own time, and therefore maybe I may use that other language elsewhere in another forum. But when it comes to my court and my judgments, I would refrain totally from using such words.
In a criminal case, maybe people presented evidence that people were talking in Sheng.
Yes.
How do you handle it?
Well, if it came up in evidence of, it will be good to quote the words, but using apostrophes, because you're restating someone's words. You're not going to make them your own. So the best usage in language is to put apostrophes, opening and closing quotation marks.
Okay, thank you very much.
Yes.
I wish you the best.
Thank you.
Thank you, Chair. Good morning once again, Council.
Good morning, Commissioner.
Allow me to pick up from where Judge Ibrahim has left with regards to your writing.
Yes.
Where is the place of precedent in submissions or even in judgments?
Case law.
Yes.
The place of precedent is in reducing the facts to applicable circumstances, or rather comparing similar facts or situations to the current case at hand. Yes.
And at what point do you then incorporate it in a judgment, if you are appointed a judge?
Yes.
Or as an advocate? As an advocate, because I've noticed
Yes.
you do not make reference to any decided cases within the body of your submissions.
I would, like I said, after breaking down the issues, the facts, and then arriving in a bid to arrive at a conclusion, that is when I will cite precedent, applicable precedent, in support of the current circumstances, and which will lead me now into the decision that I am going to make.
So then why did you leave out in about 3 of your decisions? You've not made any reference to precedents within the body of your submissions.
Perhaps you're talking about the case of Charles Muchemi.
Okay, there is a Court of Appeal on the land matter that you had mentioned before. That's Mahar,
Manohar
yes,
Singh,
and
yes.
Caroline Njeri. There is no reference to any decided case within the body of your submissions,
Yes.
and this is a Court of Appeal matter.
In that case, I felt that the facts were quite unique, and if I quoted a lot of precedent, I would lose the issues at hand.
Okay, and
Yes,
even the
that
Njeri.
is at the time, that is what I felt.
Okay,
Yes.
the Njeri, the Court of Appeal Njeri chemist case, again, you didn't make any reference to decided cases?
The Njoroge chemist's case in the Court of Appeal,
Yes.
that was, we had actually, it was an injunction pending appeal, and at the beginning, when we argued the application, we had actually submitted the case, the cited authorities to the court. There was already an interlocutory injunction pending appeal. And,
So, but the issue is, why don't you, if you're going to a Court of Appeal, you know, that's
Yes.
a very superior court, why not make reference to decided cases?
I may not recall very well, but I think I quoted the case of Equity versus Westlink MBU.
Okay.
Yes.
Again, on the issue of language,
Yes.
in the initial High Court, Court of Appeal matter that I just mentioned, the Caroline Njeri Mushigi matter,
Yes.
there are certain terminologies that you have used, such as dad, the orders are absurd, the only conclusion that any legal mind analyzing the evidence on record, the language. There's been concern about judges and magistrates using certain language, and we all know our legal writing and drafting skills. We are required to adhere to certain standards. So why would you make reference to your colleagues' decisions or pleadings as absurd, dad?
I was referring to the check that was issued, a dad check, meaning that, sorry,
I understand the meaning.
a dad
yes,
undertaking.
Yes,
Yes, because counsel gave a professional undertaking when he knew very well he was not seized of the funds to purchase. So as an advocate, you're only supposed to give your professional undertaking if you
I
have
understand
already,
the context. The
Yes.
issue is the language. The language, even the issue of saying the absurdness and conclusion by any legal mind,
Yes.
meaning the judge. Are you trying to imply that the judge must decide your way, or the issue is more of the language, which I think Judge Ibrahim had asked you about?
Yes,
Professional and courteous language.
yes.
Yes, how are you going to ensure that you improve on that?
I will endeavor that our legal system is very adversarial, but when you sit on the bench as a judge, you're not taking sides. You're not on the side of the plaintiff, you're not on the side of the defendant. We advocates tend sometimes to be overzealous in defending our clients, and but when you sit as a judge on the bench, you have to look at both rationally, and in that case, then you will not really lean on one side, and you will not then have to use such words.
Okay.
Yes.
And in another matter that you have shared, the sexual offences case,
Yes.
your appeal was around sentencing.
Yes.
So what are some of the considerations? I know as sexual offences matters are not, you don't have the original jurisdiction,
Yes.
but in matters that are seized before you
Yes.
in sentencing, what would you consider before sentencing? in a criminal case?
I will consider the age of the accused person. I would consider their health situation. I would consider their remorse. Are they remorseful? I would also consider the circumstances under which or in which the offense was committed, and particularly also the age of the victim. Yes.
Okay, and at appeal level, when you're setting aside or reviewing the sentence in a sexual offense matter?
I would consider that, I would consider whether whether the accused, I would consider whether the accused in his evidence or in his defense raised the issue of the age of the minor. I would also consider the mitigation that he gave, and I would also still consider his age.
Okay, in your submission, among the things you have asked the court to consider,
Yes.
is that the complainant, that is a 15-year-old girl,
Yes.
the complainant admits having been friends with the appellant and went to meet him on her own volition. And then part 4, the complainant, that is now the 15-year-old girl, having not contracted any disease or fallen pregnant, but was able to proceed with her education. Why do you think those two issues that I've read out, the court should consider those two issues?
Yes, the impact of the offense on the victim.
Yeah, but this one you're asking the court to consider to reduce the sentence for the accused, the accused person, the convicted person. Why is it necessary for you to consider not the victim,
Yes.
but in terms of reviewing sentence?
The impact on the life of the victim is important.
But here you
Yes.
have asked the court to consider these two issues. There are 4, but of particular concern are these 2
Yes.
in reducing the sentence of the convicted person.
Because they were not considered in the trial court.
Why is it necessary to consider
Yes.
that a person was not did not fall pregnant, neither did they contract a disease as a mitigating factor before sentencing? Why is it important to you? Because that is what you have put in your submissions for review of sentence.
My consideration was the fact that the victim will somehow be able to salvage their life, and it's not totally lost, as opposed to the harsh sentence that was handed to the accused person by the trial court.
Okay. It is said that the Kenyan judiciary is not pro-poor, and the Constitution requires all of us to promote equality.
Yes.
And Bangalore principle of judicial conduct equality is among the principles.
Yes.
So in interpreting the law, how are you going to ensure that you inculcate the principle of equality in your decisions?
By making decisions that cater for the social and economic circumstances of litigants appearing before me, by considering their cultural background and age, their gender, and even their economic status.
Okay, thank you, Chair.
Thank you, Chair. And welcome again, Agnes.
Yes.
Would you share with us how does the judiciary contribute to the national development goals of this country? Very briefly.
Yes, a strong judiciary guarantees, or rather ensures, a strong economic situation of a country. If investors are confident that they can do business in this country, and where disputes arise, particularly in contract or even in their investments, that they're going to get a fair and reasonable decisions, then it puts ahead our economic situation. The judiciary also has come up with other alternative dispute resolution forums like mediation, which ensure that disputes are resolved within the shortest time possible, and that makes for a strong economy of a country, and people are able to do thriving business. The judiciary also promotes the constitution. And in a country where the constitution is promoted or given strength, then the economy of that country will definitely thrive. Yes. Yes.
Okay. My second and last question is that you explain the role of the judge today.
Yes.
How it has changed from that of a traditional judge as we have always known it.
Thank you. The judge today has an obligation to developing the law and promoting the constitution. The role of the judge today is not just as an arbiter of disputes.
I want to hear what has changed.
Yes. The role of the judge has now, there has been realized the need for empathy, and the judge is now recognized as a strong pillar of society and even the economy of the country.
Is there any role that ICT plays in the role of a judge?
Yes, yes. ICT ensures that there is faster delivery of justice, and that there is easy access to justice, because decisions are easily available and the court system is readily available.
Thank you. Commissioner Rand.
Thank you, Chair. Good morning once again.
Good morning.
Okay, if you're successful to join the bench as a judge, you will find occasionally you will encounter advocates who, for lack of a better word, I'll describe as cantankerous. You know, those who come and they do not want to listen. They want to take charge of your court. They want to direct how you're going to conduct proceedings there. How do you purpose to deal with such advocates, or even parties for that matter?
Thank you, Commissioner. I will first and foremost ensure that I conduct myself with decorum, because what you give is what you get in return, although sometimes it doesn't exactly work that way. I would take up measures by ensuring that if an advocate is, I will take up measures to ensure I have full control of my courtroom. I will not give room for people to express their private or their personal side in my courtroom.
Those measures?
I would make use of the court bailiffs and other stuff to make sure there is order in the courtroom, and I will constantly make reminders that of the need for decorum in the court, so that we can move towards a speedy resolution of disputes. would make use of the court users committee to sensitize advocates, particularly, and even litigants, on the importance of maintaining decorum in court.
You will not have difficulty stamping your authority and taking charge of your court. You don't see yourself having difficulty achieving
I will
that?
not. I will not.
Okay.
I will not.
Okay. The second question I have for you, you are currently operating your own law firm.
Yes.
How many associates do you have?
Currently, I do not have any associates in my law firm.
Okay.
Yes.
And just giving a rough estimate, what is your workload like?
In terms of litigation,
Yeah,
I
the cases you have. Or
yes,
yes.
I am in court at least 3 to 4 times in a week on either applications or full hearings. I have
Roughly,
mentions.
like how many cases you have, the nature of clients you majorly
Yes.
attend to? Yes, that's what I want to hear.
I mostly deal with individual clients, one-on-one, not
Mhm.
as opposed to corporate clients.
Mhm.
I have a big portfolio. I lost count at some point. And my law firm has grown from clients referring other clients. I can say with confidence that at least every client I worked for has brought back at least one other client. And that is how my law firm has grown.
Okay.
Yes.
Do you have a performance measurement framework in your law firm?
On myself, I have targets.
You are not alone in the law firm, are you?
No, in terms of
assume-
advocates,
yes.
I am the only advocate in the law
But you
firm.
have other staff.
Yes, I have a secretary who also serves as a receptionist. I have a court clerk. The measure for my performance is actually something that I do according to my targets. As for the staff, I gauge their performance, and where there is need, I call them and have a talk with them on how
What do
the
you use
areas
to
improve.
gauge? You just look at how they perform. Are there instruments you use?
First of all, I believe in discipline. I'm a strong upholder of discipline and timeliness. I believe that if you're not able to keep your time, I think you may have challenges performing your work to required standards, because then if you, like, for example, you come into the office at 9 and you're required to be elsewhere at 9, you're not performing. For me, it's on a day-to-day basis. Yes.
Okay, now before we embarked on this exercise, we
Yes.
engaged some of our stakeholders
Yes.
just to get a feel of what they want
Yes.
in the kind of judges we are to recruit.
Yes.
One attribute that featured strongly was that they needed someone who's a hard worker.
Yes.
So now what would you use to persuade this commission
Yes.
that you are a hard worker?
I have submitted testimonials, which are mostly from people that I have worked with. But on myself, I diligently perform work that is given to me by clients, and that explains the natural growth of my law firm. Like, I have not had to go soliciting for work or such like things. I believe in delivery. I believe in substance and delivery of substance. Yes.
Okay. Now, lastly for me, under Order 11,
Yes.
we have the case management conference.
Yes.
At the end of that conference, that procedure, can you give us 3 kinds of orders you are likely to issue as a judge?
I can request parties to amend their pleadings if their pleadings are not to par.
More like the final orders you will be making at the end.
At the
You
end,
see, when they amend, you're still at the stage of pre-trial, isn't it?
very
Then
well.
you'll still look into those amended pleadings. I'm talking about at the end of the exercise, the case management exercise, 3 orders you're likely to give.
certify the matter ready for trial, give a hearing date, or give directions as to speedy prosecution of the matter. Like, for instance, can we dispose of this matter by way of written submissions?
Okay, that's not what I was looking for, but yes. Any other?
At the end of pre-trial, I might as well, I might also require for, that is discovery and all that has been done.
That's what you do in the pre-trial?
Yes.
Yes.
I might refer the matter to, I might decide my court does not have jurisdiction.
Okay, thank you.
Yes.
Thank you, my lady.
Commissioner Excellency Ruto.
Thank you very much, CJ. Now, can you tell us the guiding principles of leadership?
Thank you, Honorable
And
Commissioner.
integrity.
Sorry?
Leadership and integrity.
Diligence, efficiency, timeliness,
Specifically as in chapter 6.
Competence, integrity, honesty.
Okay, and now in leadership, what would you consider as transformational leadership style? And are you one such person?
What I will consider my transformational, please say again.
Would you consider yourself as a transformational leader?
Yes.
Can you
Yes.
explain?
Because I am a person who likes to see progress in society, and I have a keen sense of responsibility. I always take charge of my civic duty. Like for instance, I will participate in every general election, the Law Society elections, or any other forum where I'm required to exercise my civic duty. I participate in community development. I help the less able members of society, not just by giving them money, but considering the fact that I'm a lawyer and I have come across quite some experience and knowledge, I am able to volunteer to render advice to members of society, even when there is nothing to be gained from it. Yes.
Thank you, CJ.
Thank you, Honorable CJ. Good afternoon, good morning, Honorable Miss Agnes.
Good morning, Honorable Commissioner.
Okay. As a follow-up question from what Commissioner Ruto has asked, maybe you could tell us what integrity means to you.
A person of integrity is a person who is not likely to be swayed by selfish or self-persuasions, who will deal with given set of circumstances, regardless of whether the outcome favors them. In a sum, to say a transparent person. Transparency.
Would you consider yourself, or would you term yourself as a person of integrity?
Yes, I am.
Okay.
Yes.
The question about guiding principles of leadership and integrity, maybe you will need to go back and refresh yourself on those ones.
Thank you.
Please tell this commission, have you ever come into any conflict with the law in the past?
At a personal level?
At a personal level, yes?
No.
You've never come into conflict with the law?
No.
Any other way?
Not that I can think of.
Okay.
No.
as we do background vetting for candidates, we work with different agencies, different government agencies to provide us with reports, and you're also expected to do that. Have you cleared with the different government agencies that we work with?
Yes.
Have you encountered any issue?
No.
Okay. My other question to you would be regarding corruption in the institution. Judiciary is seen to be a weak link in the fight against corruption. What is your view on that?
As much I will say there is room for improvement, I know for a fact that the judiciary has really evolved from what it was before, and we as advocates actually feel the effects. The levels of corruption have drastically reduced, and I believe it's a work in progress. Yes.
If you're successful and you become a judge, what are some of the measures you're going to put in place to ensure that these incidences are eliminated or reduced?
Incidences of corruption?
Corruption in the institution.
I will start by sensitizing stakeholders, and that is court users, the subordinate staff, and my colleagues even, on the vision of the judiciary that we are undergoing a transformation, and we cannot be accused of corruption anymore. We need to move forward from that.
So sensitization is the only way? Any other way?
Myself, I would make sure that the system is foolproof, particularly in the station that I'm handling. I will make sure that all the systems are transparent in the way that leaves no room for corruption.
How do you do that?
I am used to taking charge at my practice. I am used to taking charge of each and every work that goes on, and I would really supervise in a way that anybody who might be tempted that way feels challenged. I sensitize people regularly that, you always be honest even when one is looking. Apart from sensitizing and putting systems in place, I would ensure that myself, the way I handle myself, leaves no doubt that I am beyond, yes, I am beyond corruption, and I in the hope that that might inspire others to follow.
Okay, thank
Yes.
you. My final question, as a leader and as a judge, if you're successful, how are you going to advocate for diversity and inclusivity in the institution?
Again, I will use the word sensitization, and by sensitizing the community or even the people around me on the importance of supporting each other regardless of your age, your gender, because I believe that whether man or woman, it is only if we support each other that we can go forward. I also, by encouraging or supporting the weaker members of the society that we are living in.
Okay.
Yes.
Any
and
other?
Also information, giving information, really.
Why do you think it's important to advocate for diversity and promote diversity and inclusivity?
Because I believe that everybody has something to contribute, even the weakest member of our society.
Any other reason?
And it's also because our Constitution, it is my duty under the Constitution to uphold diversity.
Okay.
Yes.
Thank you, Honorable CJ, and I wish you all the best.
Thank you.
Thank you very much, Ms. Njoroge, for availing yourself for this interview. I think this brings us to the end of the interview. We will contact you when we complete the exercise. But before we release you, we always give a candidate an opportunity to ask us a question if you have any.
Thank you, Honorable Commissioner, Madam CJ. I do not have any question, but I'll take this opportunity to thank you all for having me and engaging with me. And I also wish you the best as you look for the right candidates to steer our judiciary ahead. Thank you.
Thank you, and keep up the good work that you are doing in private practice, representing clients in our courts.
Thank you.
All the best. We'll get in touch with you.
Thank you.
Mm.